All right, are you Rebecca Rideau?
Yes, ma'am.
And Ms. Rideau was previously in court, entered pleas of guilty in cause numbers 23-0928, 23-2106, 23-2107, and 24-1925. All of those were theft of property with previous convictions. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
The defense said.
State has, Judge.
And there was no agreement. This was just open to the court. Is that correct?
Yes, Your Honor.
I believe so, Your Honor. I didn't represent her at the stage where she entered the plea.
Okay.
My understanding is that
They were open. And are there any additions or corrections to the pre-sentence report?
None from defense.
Not from the state, Judge.
In addition to reviewing that, the state has filed a couple of things. One is a motion for me to run any sentence.
As proceedings continue, the state requests the judge to stack Rebecca's sentences, meaning she would serve them one after another. That could mean years behind bars. Her defense attorney pushes back hard, calling the state's move harsh and excessive. He argues that Rebecca's situation doesn't stand out enough to justify such punishment. The courtroom feels the tension rising. Is this justice or just punishment? Would stacking her sentences be fair, or do you think it's too severe for theft charges?
And then he has filed a sentencing memorandum as well, in addition to a motion for me to deny discretionary jail credit. So, Mr. Kimler, if you would like, you may proceed.
Your Honor, I would just note that seems to be an aberrant practice as far as harshness that the state is attempting to exert on this defendant. And I don't know that it stands out from the queue of other cases before this court to deserve such treatment, but it is what it is. I would just observe, first of all, regarding the state's posture on consecutive sentences and the denial of discretionary jail credit. The defense certainly has criminal history, but it's not to such an extent or degree, in the circumstances the individual cases aren't such to the extreme degree that it would warrant accumulation. And certainly the denial of her jail credit is something that is problematic. I don't know exactly which jail credit the state is attempting to deny her, but obviously if she's been in pretrial detention on these cases, it seemed that she would be entitled to that jail credit without much.
Rebecca's defense begins to unfold a deeper story. Her lawyer brings up mental health struggles, a military background, and how she's been self-medicating because she can't afford proper treatment. He explains she turned to theft not out of greed but desperation. A powerful emotional moment, but not everyone in the room looks convinced. The question hangs in the air. Should mental health history excuse repeated crimes, or does the law have to draw a line?
A general discharge, and there was notations there as far as the pre-sentence report that would involve some health issues. I believe her to be mentally competent. Now, I, of course, wasn't her attorney when she entered the plea, but I would assume that she is mentally competent then as well. Although, as I said, she does have mental health history. I think that plays into her present situation with the theft cases that she has. You would note in the pre-sentence report where it's indicated that she was unable to afford the mental health treatment and the pharmacological remedies that are provided through prescriptions, and that she was self-medicating and had turned to theft in an attempt to maintain funds necessary to self-medicate. She indicates in the report that her memory indeed was impaired on 3 of these offenses, and she doesn't seem to remember this. She doesn't attempt to minimize or mitigate her conduct in that regard, where she does in fact indicate that she accepts responsibility fully for her actions. But I think that that's indicative of, again, the circumstances surrounding these offenses that, of course, I guess it seems everyone in front of the court these days is finding mental health issues as something that mitigates their criminal conduct. But I do think that in this case it is well documented, going back again to her military history, that she has suffered from that.
The defense suggests probation, hoping the judge might consider it due to Rebecca's mental state and prior efforts to work. But the judge quickly shuts that down. making it clear probation is off the table. Rebecca's lawyer presses on, asking at least for concurrent sentences and credit for jail time served. It's a desperate attempt, one last shot, to soften what's coming.
While they're not recommending probation for Ms. Rio, they don't rule it out.
Well, let's not talk about probation.
Okay.
Yeah.
All right. I'm sorry, but there is a paragraph where
Well, it is an option, but that's not realistic on what's going to happen today.
they were mentioning that she'd be assessed for the specialized mental health caseload.
I understand that.
So just to note that is in the report.
Thank you.
If the court isn't inclined to consider probation for Ms. Rio, then certainly I think that while she's serving whatever sentence the court gives her, she'd have the opportunity to try to reflect on her actions and perhaps reassess those, where she is with this. And as far as addressing her mental health issues when she gets out, that she'll be able to do that and maintain her law-abiding lifestyle. She has maintained employment, I think 3 years for the city of Beaumont, if you will. Is that right, Ms. Rio? She has maintained gainful employment in the past when her mental health is stabilized, and I would anticipate she would be able to do that in the future if she does have the proper mental health regimen. That would be my argument for probation, obviously, but the court's not inclined for that. So we would ask for a sentence, certainly.
Then the defendant herself finally speaks. Rebecca breaks down, her voice trembling as she apologizes. She says she's tired of being in trouble, tired of missing her kids' lives. She talks about missing her daughter's graduation, her child's school events, and the pain of being absent. The courtroom grows still. It's a raw moment that reminds everyone that behind the criminal record stands a mother begging for another chance. Do you believe her emotions are genuine, or is it too little, too late?
And my mama got to take care of. I'm just tired. And I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I'm old. I missed my daughter's graduation. She spoke at Westbrook graduation. I was not there. I'm tired. My baby asked me why I'm the only mom. I'm not at mom's and muffins. That is embarrassing for my kids. I want to go for my kids. That's what a chance to do for me. Mama, thank you. I want to thank you.
Sure. So.
But the judge doesn't waver. She reminds Rebecca of her history: 5 revoked probations, multiple thefts, and even a past robbery. No one put you here but yourself, the judge says firmly. Then the prosecutor steps in, and he's had enough. He calls Rebecca's story the same old song, saying business owners are tired of people like her stealing from stores and then asking for sympathy. His words are sharp and unapologetic. Whose side are you on? The emotional plea of the mother, or the frustration of victims and store owners?
There was a robbery that you got some time for in 21, and then you're here now on 4 more theft cases. And so, I mean, it's unfortunate and it's sad for your family, but no one put you here but yourself. Mr.
Judge,
Coleman, I know what you're...
you've essentially hit the things that I want to hit. That in addition to what I put in my sentencing memo, I won't belabor that, Judge. The only thing I would add is she says she's tired of this. I tell you who else is tired of this. It's our local store owners and business owners who are tired of people just walking in and taking what they want from them. She stole from a sporting goods store, from JCPenney, from another clothing store on a couple of occasions. They're tired of it too. They're the same old song. Just different defendant. I apologize. Give me another chance. I've got all these issues. In fact, I go one step further than the same old song. It's the greatest hits, Judge. It's what you hear time and time again, and I'm sure she said it back.
The defense pushes back, arguing fairness, saying other defendants with similar records have received lighter treatment. But the judge is unmoved. She agrees the situation is troubling but stands by her responsibility. The law must mean something. She warns Rebecca that this might be her last chance before harsher penalties come in the future. The courtroom energy turns cold. Reality is setting in.
Yeah, but
I can't give the max and do that.
that's my understanding.
That's your understanding.
Yes, that's it in a nutshell, Judge. And I just say this is a case of that to be considered. And I also say this is the appropriate case to accumulate her sentence, Judge. She needs, in my opinion, some stronger medicine than what she's received in the past in order to impress upon her the impress upon her the fact that she needs to stop engaging in this kind of behavior, Judge. Thanks, that's all I have.
Thank you.
I would just argue from the standpoint of equal protection as far as the other defendants listed.
Well, so here's,
What-
speak up so she can hear.
I would argue from the standpoint of equal protection of laws, Your Honor, what distinguishes her from the other defendants that have been before this court who are similarly situated with similar criminal histories?
Well, here's where,
I'm
okay.
sorry.
Here's where I am on this. I don't disagree with Mr. Coleman. I appreciate that he's gone out and tried to figure out some stronger things to do on some of these cases where we are stuck with state jail felonies. I've been very frustrated with that in the past. I don't know that this is the one to start with either necessarily, but it's not going to be out of the realm of possibility, depending on someone's criminal history, what their prior sentences were, and I don't fully disagree that this isn't one of them. I'm not going to do that this time, but I do appreciate the thought that went into this and don't necessarily disagree that there's going to be a time that this might happen, including to you if you continue to do what you've been doing for your whole life. Because if you're back in here after today on a theft, I can assure you that Mr. Coleman will remind me what he asked me to do that I didn't do. And I will on that. Do you understand? So if you want to be there for your kids, then you got to figure out something other than stealing. I'm going to find in all of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 0928, find you guilty of the state jail felony of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2106, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2107, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24, DCCR 1925, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases, I am going to run them concurrently, which means together at the same time. Part of the reason I did the 24 months is because I'm going to see that when you come back, that this is the max on a state jail felony you can get. So next time, whoever's here, if it's me or someone else, is going to see that you have progressively gotten worse, your sentences have gotten worse, and when someone like Mr. Coleman files something asking that these run consecutive or that we deny credit, that's likely to happen. I'm handing you in all four of your cases the trial court certifications. These show that these were not agreements, and so you have not waived your right to appeal. You can talk to Mr. Kimler about that. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Kimler. Good luck to you, ma'am. You can go back with the bailiff. Thank you for